Hi, I'm Steve Carlson, seeking to run for president in 2016 in a primary for the Minnesota Independence Party. But Al Franken and his DFL have corrupted Minnesota politics and attempted to annihilate the Independent Voters Party, giving us a brave new United States that in no way resembles the nation we founded and nurtured as a democracy, a Republican form of government. I've just brought this to the Minnesota Supreme Court in an election petition. That's under Minnesota Statutes 204B.44D, seeking orders regarding present legal duties the Minnesota DFL officials have to correct their corrupt election practices. I will read from this petition. As you listen to these videos, you'll realize the extent of the corrupt practices of the DFL and even their attorneys like Lori Swanson, who's the elected Attorney General, and how this flies in the face of long-held precedents of the United States Supreme Court and even the Minnesota Supreme Court. I'll even explain how Minnesota's own Bill of Rights demands that our vote in elections be protected now. In the Supreme Court of Minnesota election petition of Stephen W. Carlson, Steve Carlson, concerning the 2014 U.S. Senate race, concerning the decertifying of the Independence Party as a major party, and concerning the 2016 U.S. President race with the Independence Party as a major party. And the respondents in this petition are Governor Mark Dayton in his official capacity, Minnesota Secretary of State Steve Simon, Minnesota Attorney General Lori Swanson, Minnesota Democratic Farmer Labor DFL Party, Al Franken, contestee, Betty McCollum, 2012 contestee. This petition seeks, among other things, to find the Minnesota courts under the two election contests filed on December 2nd and 2014 and December 4th, 2012, that they have a present legal duty to collect evidence, including discovery processes of interrogatories, depositions, and the full scope of discovery under civil rules. These should be free of charge, including depositions and copying of relevant records for the contests. And that further, the order pursuant to 204B.44D, that the present transcript and record of the 2012 and 2014 contests should be immediately made available at no charge to petitioner and the parties, and included in the evidence forwarded to the U.S. Senate and U.S. House pursuant to Minnesota Statute 20912. That's the Congressional Office Election Contest provision in the Minnesota law. Now, pursuant to Minnesota Statutes 204B.44D, petitioner and Minnesota Independence Party, IP, U.S. Senate primary winner in the 2014 statewide Minnesota elections, Stephen W. Carlson, petitions this court further for an order. I'm going to describe that order, but first I want to talk a little bit about what is the CCEC. That is the Comprehensive Congressional Elections Code, and I didn't make that up. It basically is a phrase derived from the United States Supreme Court in Smiley versus Holm. That's a Minnesota case that went to the U.S. Supreme Court about redistricting. Could the governor veto or could he not veto the legislature's redistricting law? Now, this election petition statute, which is 204B.44, and all the statutes and the constitutional provisions of both the U.S. and Minnesota constitutions referred to in the instant petition are part of the Comprehensive Congressional Election Code. This is mandated by the U.S. Constitution, Article 1, Section 4, that the state needs to determine, prescribe in advance, and not as you just go through the election, just haphazard decisions, but to prescribe the time, place, and manner of holding elections in Minnesota for the Senate and for the U.S. House. Now, under the U.S. Supreme Court case Smiley versus Holm from 1932, the legislatures in the various states enact the making up of enact the making up the CCEC. And they are passed in the way followed in passing any law in the state. And so the governors at the time the CCEC was passed in Minnesota also participated in making the law. While in another state, where the governor's signature would not ordinarily be required in passing laws, the governor could not veto it and therefore didn't participate. Thus, in Minnesota, the state legislature and the governor collaborate as mere agents of the people of Minnesota in aid of the selection of federal senators and representatives. However, no Minnesota court, including this court, the Supreme Court, under the Minnesota CCEC, can usurp the power of the framers in enacting Article 1, Section 4, or of the two houses of Congress, Senate and House, in determining the election's return and qualifications of their membership. That's because of Article 1, Section 5. By arrogating to themselves the power to frustrate the operation of the CCEC. And in the instant petition, it is strictly alleged that this court and the Ramsey County District Court, including this panel you have appointed, have in fact worked deliberately to frustrate the operation of the CCEC, not only in my cases, but notably so. So this irregularity in the conduct of the U.S. Senate election, as well as the 2012 CD4 House election, that's Congressional District 4, where Betty McCollum is, excuse me, and constitutes serious material and deliberate violation of provisions of Minnesota election law. And this is not just a failure to enforce this law, but it is the other grounds in the contest which I have brought in, which I will discuss in the beginning of the next video. So the order that I'm looking for, let's see if there's anything else I need to know. I was in 2010 and 2012 the nominee of the IP for the House of Representatives from the CD4 district. And also in this petition, what I'm required to do is to describe the error, omission, or wrongful act and the correction sought by the petitioner. And so that's what I'm doing here. So you'll notice I'm always talking about violation of a duty concerning an election. And that's the error or wrongful act. And then to correct it, I asked for a number of things. And the first thing I asked for is a finding for the revocation and invalidation of the Al Franken Senate election certificate issued December 19th, 2014. Now at that time, it was illegal to issue that certificate, but I'm going to tell you how they did it anyway. A finding that Minnesota Governor Mark Dayton and current Minnesota Secretary of State Steve Simon and the Minnesota Attorney General Lori Swanson have a present legal duty under Minnesota statutes 209.02, which describes grounds for a contest, 209.12, which describes how a congressional office contest should be carried out, and 204C.40 subdivision 1 and 2. What those do is bar the issuing of an election certificate to Al Franken when Al Franken is involved in an election contest, which has not yet been finally determined, and insofar as Minnesota courts can determine it. And in violation of these, which they did, now they have a present duty to invalidate the election certificate of Al Franken, unlawfully issued December 19th, 2014, and to the U.S. Senate at the same time, they issued it. And that by not doing so, each of them violate a duty concerning an election and conduct the U.S. Senate election in Minnesota irregularly and in serious material and deliberate violation of provisions of Minnesota election law by continuing to fight against the election laws of the state of Minnesota. And two, I'm asking in this order for a finding regarding the duty to carry out the provisions of the congressional contest. So a finding that this court, Minnesota Supreme Court, or some judges appointed by this court have a present legal duty to carry out the contest instituted by petitioner December 2nd, 2014, which contest was pending, not finally determined by a court of proper jurisdiction at the time the Franken certificate was illegally issued to the U.S. Senate. and that Lori Swanson has a present legal duty to correct the unconstitutional and unlawful legal positions her office has been asserting on behalf of the Office of Secretary of State, Mark Ritchie, and now that's Steve Simon. And that Mark Ritchie and Steve Simon had and have a present legal duty to apply the law as it is prescribed by the Minnesota legislature, and not to seek a legal pretext to avoid and refuse the Minnesota CCEC, and that each of them violates a duty concerning an election and conducts the U.S. Senate election irregularly and in serious, material, and deliberate violation of provisions of Minnesota election law by continuing to fight against the election laws of the state of Minnesota. And then number 3, a finding regarding the requirement of Minnesota judges to carry out duties specified in the Congressional Office Contest Statute. A finding that the court or some judges appointed by this court must perform the duties specified in 209-12 and are not allowed by law to avoid this duty, including disallowing discovery procedures under Minnesota Rules of Civil Procedure were not in conflict with Chapter 209, allowing petitioner contestant, that should be contestee, to collect evidence on the 204 U.S. Senate contest, and to allow for sufficient time to present legal arguments to define its materiality and nature, and on the 2012 U.S. House contest as well, to collect that evidence, and that this court and the Ramsey County District Court in 2012 and the panel appointed by this court in 2014 that they are going to have a legal duty, that they violate a duty concerning an election and conduct the U.S. Senate election irregularly in a serious, material, and deliberate violation of provisions of Minnesota election law, but continuing to fight against the election laws of the state of Minnesota by blocking discovery and collection of evidence to forward to the Senate and House in accordance with 209.12. And next, I seek a finding in an order regarding the rescission of the Minnesota Independence Party and loss of Minnesota's major political party status based on the invalid Franken election. I want to rescind that loss. A finding that the Secretary of State, Steve Simon, has a present legal duty to rescind the deprivation of the major political party status of the Minnesota Independence Party, called the IP, based on the 2014 and 2012 elections, because in those elections, the practices properly identified and contested by petitioner, as set forth in more detail infra, imposed burdens that fell unequally on independent candidates, including petitioner, or on the IP as a small political party, thus impinging by their very nature on the associational choices of Minnesota independent voters, which are protected by the First Amendment of the United States Constitution, and so discriminated against those candidates, including petitioner, and voters and party whose political preferences lay outside the existing political parties. That's the Democrats and Republicans. These are what I mean by the independent voters in this petition. And I refer to a case called Anderson versus Celebrezzi. Now, without court action, the major political party status would have expired January 1st, 2015. And that's about 3.5 months ago at this time. So then further, I seek in the order that it describe and evaluate the grounds of the election contest filed December 2nd, and a finding that, contrary to any misapprehension, that a congressional election contest in Minnesota is supposedly statutorily limited to simply finding the candidate with the highest number of votes legally cast and giving him or her the election certificate. And I refer to the case Franken versus Palenti. They call this Franken 1. This is from 2009, Minnesota Supreme Court. And I want to describe a little bit what happened in that, because it's created some misunderstandings about our election law. The court has done great mischief by your misstatement of the Minnesota contest and petition law by wrongfully narrowing the scope of your self-described functions under the CCEC. Your Franken 1 opinion contained dicta, or words, which seem to suggest that Minnesota Statute 209-12's language and construction statutorily limits any contest to just the issue of which candidate received the highest number of votes legally cast and is therefore entitled to receive the election certificate. However, as your very Franken 1 opinion itself referred to, Chief Justice Knudsen in Odegaard versus Olson cited Chief Justice Hughes in Smiley versus Holm, interpreting Section 4 of Article 1 of the U.S. Constitution to stress the broad grant of authority to the state to legislate its comprehensive Congressional Election Code, the CCEC, and Knudsen set out the complete coverage as the steps required to conduct an election. And the scope of the enforcement must necessarily be broad enough to enforce the entire CCEC. Since this CCEC is mandated not only by our state's high court, but by the U.S. Constitution, that is to say, the very framers who constructed this nation with a democratic, Republican form of government. This court, Minnesota Supreme Court, simply lacks the authority to cut back the enforcement of the broad and comprehensive CCEC enacted and replace it with your own wisdom or preference. The law has been prescribed, written in advance, and you simply are not permitted to rewrite it as you go, which you did in 2009 in your dicta. Your dicta were not even material to the Franken petition, because the Franken contest was limited to just those questions you said. That is to say, who received the highest vote total. However, the issue of whether the statutory scope of 209-12 contest goes beyond the scope of that particular contest. And it simply could not have been addressed in Franken 1. Now, may it be addressed here, and it must be, and this is the case in which you must restate the original standard found in our law. Yes, the statute was designed to facilitate the Senate's powers under Article 1, Section 5, the U.S. Constitution, to determine its own membership. But it was not designed and could not constitutionally have been designed to in any way limit the broad scope of Article 1, Section 4, the United States Constitution, which grants this authority to the state to elect those members. So there's always a little tension there between those two. Now, all the court actions available under the CCEC, notably Minnesota Statutes 204B.44D, election petition, and 209.02 grounds, and 209.12 congressional office contest, simply must be and are available despite the overstatement by this court in Franken 1, purporting to statutorily limit the scope of the contest statute. Obviously, the scope of subsection D has been clarified even in Franken 1, where you say Franken brought the petition against Ritchie and Polenti, charging they had a present legal duty to deliver a certificate of election for Franken based on the state canvassing board's declaration that Franken had momentarily received the highest number of votes in the recount of the election for United States Senator. And it is that present legal duty to determine the release of the election certificate that broadened the scope of subsection D, even in that case, beyond the mere vote total covered by the first two sentences of 209-12. And in the 2014 contest, Franken sought to limit the provision to the first two sentences, ignoring the whole 4 or 5 sentences in the provision. And so your very Franken 1 precedent itself acknowledges the fuller scope of 204B.44, not limited to the particular issue of duty in that case. Franken asserted the issue was the certificate must be immediately issued, even though the contest was not finally disposed of. And your opinion was it need not issue and could not issue because of the CCEC's restrictions in 204C.40, that you can't issue this when the contest is still not determined. He's not officially or finally elected as a senator until that contest is over. Now, in this case, the issue and your present legal duty is to note that Dayton and Ritchie did issue the certificate December 19th, 2014, before this contest was finally disposed of and in violation of 204C.40. So in this petition, the present legal duty is to invalidate the illegally issued certificate and to allow this contest to go forward. This state shares power with the two houses of Congress to conduct elections for Congress, as this state prescribes. We cannot lawfully or constitutionally rework the prescribed positive law as we go along. And your court has been doing this, and it must be corrected by clarifying the scope, noting the overreach in Franken 1, which was no doubt intended to protect the state's rights against Franken's 2009 onslaught and high-powered attorneys like Justice Lillyhouse, and by finding these other issues I have brought are within the ambit of Article 1, Section 4 for this and future congressional and presidential contests. And so that was a long footnote. I wanted to describe what happened in that election petition Al Franken brought in 2009. And what I have to say then is each of the following grounds, which I'm going to go through, are lawfully and quite properly before the court and included pursuant to Minnesota Statutes 209.02 and 209.12 by a petitioner in my contest, which I filed with this court. What happened, this court, Minnesota Supreme Court, then appointed a 3-judge panel in Ramsey County, and that during that action, they somehow let this illegal certificate slip through. It's not clear whether they fully intended at every moment to do that, but that's what happened. And that certificate needs to be recalled and evidence be allowed to be taken with sufficient time for legal argument to the record using the full ambit of the Minnesota Court Rules discovery procedures on the following points, each of which constitute irregularity in the conduct of the 2014 U.S. Senate election, and also serious material and deliberate violation of provisions of Minnesota election law as referenced in Minnesota Statutes 209.02 grounds, 209.12 congressional office election contests, which are different than election contests for state office and really governed by the U.S. Constitution, where those would not cover the state office directly in the Constitution. There might be constitutional aspects to them, but it's not in the U.S. Constitution because it's not regarding the U.S. government, rather the state government. Now, each of these practices that I brought before the courts is material and serious because in the language of Anderson versus Calabrese, which was a U.S. Supreme Court case from 1983 involving John B. Anderson, each ground shows a, quote, burden that falls unequally on independent candidates or on new or small political parties, and so impinges by its very nature on associational choices protected by the First Amendment, and discriminates against those candidates and voters whose political preferences lie outside the existing political parties, unquote. And that is a quote from the United States Supreme Court regarding the rights of independent parties, independent voters and candidates. And the Anderson Court standard, Anderson versus Calabrese, set up a standard which therefore requires that in view of the character and magnitude of these asserted injuries to the rights protected by the First and 14th Amendments, the 14th Amendment simply applies the First Amendment's protections to the states because it's part of the federal Constitution, and without it, it was not seen as applying to the states, but only to First Amendment rights under the federal government. But it would still have allowed the states to violate your First Amendment rights until the 14th Amendment was passed and extended that to the states. Each of these practices, therefore, needs to be shown by the state to be justified based on any interests that might be asserted by the state and cannot be left to the whim and fancy of the state of Minnesota courts under the CCEC. That is, the CCEC has to govern, not their whim or fancy. The final action against the major party status of the IP, depriving it based on this invalid election, is the culmination of these irregularities of these grounds in the conduct of the 2014 and 2012 election practices and of serious, material, and deliberate violation of provisions of Minnesota election law. Because each of these actions in these two elections, as set forth in this petition, constitutes the imposition of a burden which fell unequally on petitioner and his party and the Minnesota independent voters, and so impinged unconstitutionally on our associational choices protected by the First and 14th Amendment. Furthermore, with respect to the OSS duties to the 2016 U.S. presidential election, Secretary Simon has a present legal duty to rescind the operation of law depriving the IP of major political party status, because we may not be so deprived based on this invalid, unconstitutional election for U.S. Senate and other statewide offices, in which IP presented a candidate in 2014. The deprivation of petitioners' right to file for U.S. President, to run in an independence party primary for the 2016 statewide presidential race, while allowing the Democrats and Republicans to continue on the ballot in 2016, is a burden that falls unfairly on petitioner as a candidate and the Independence Party and the independent voters, all of whose political preferences lie outside the existing parties. It is a grave injury to the First Amendment associational rights, therefore must be, but cannot be, justified by the state. Hence, the deprivation of major party status imposed on us must be reversed by this court. And in the next video, I will go on to get into each of these grounds, the first one being Minnesota voter quotas.